Hi, my name is Cindy Gallardo. I want to tell you a little bit about Vincent Davis and his associates and how they've helped me in my situation. I was made false allegations by my daughter. A couple days later, CPS came and took my kids. My husband and I went to Mr. Davis's office. Again, the reassurance and just calming us down, letting us know that everything was okay and just telling us what our next Mr. Davis has given his personal number to contact him, and he gets back to you right away. There's no other attorney that I feel has done that.
Welcome to CPS Office Hours. I'm Attorney Vince Davis, and today I'm sounding the alarm. This is not a drill. This is not a waiting game. This is war. In the next 30 minutes, I'm going to walk you through the 12 most dangerous misconceptions that cause families to lose their children in the CPS system, all because they believed they had time. They had time to wait, to act, to strategize, to hire their lawyer, to work with their lawyer. Listen, time is not on your side. And in a CPS case, this is especially true. The longer you wait to hire the right attorney, the more damage is done, sometimes permanently. You have to work with your court-appointed attorney now. And if that's not possible, you should start looking for an attorney that you can work with. If this live stream opens your eyes, share it. Share it with your friends, your relatives, and I'd ask for donations to keep the channel going. And if you're in a CPS case right now, contact my office. Let's get to work. The phone number is down there in the bottom right-hand corner. All right, misconception number 1. I'll wait for my first court date to get serious. By the time you're in court, the social worker has already filed her petition against you, the allegations. The social worker has already filed the detention report, a report that will be used and considered in evidence at your first hearing. Now, if the social worker has time to complete these documents, what do you have time to do? What do you have time to prepare and submit to the court? The judge is going to, by law, rely on that social worker report. And are you ready to fight it? In 99.9% of the cases, you don't see the allegations in the reports until the morning of your hearing. Court starts at 8:30, you get your report at 8:30. You need to start early. And start intervening in the case now. That's how you stop the narrative from becoming law in your case, which is used against you. Consider this. Hire an attorney the day you hear from CPS, not from the day that you go to court, lose the first hearing, scratch your head, and claim that's all corrupt. You lose cases because you're not prepared and you don't have the evidence. But nobody told you. And unfortunately, as I've said many times, in our English common law system, ignorance is no excuse. Misconception number 2. Court-appointed attorneys will handle everything for me. Many public defenders are overwhelmed with the number of cases they had. 2.5 decades ago, maybe more, when I was a court-appointed attorney, I sometimes carried a caseload anywhere from 350 cases to 450 cases at one time. It's one of the reasons why I left being a court-appointed attorney. You get too many cases. It's not that you're a bad attorney. Not at all. You have too many cases. So how are they going to fit you in when they pick you up and you're number one of 300? You know, many court-appointed attorneys have limited time to prepare objections or prepare an aggressive defense. And that's not because they're inept, it's because they don't have the time. Sometimes your case may require some type of motion to be filed. The odds are that the court-appointed attorney may not have time to do that. What's the fix? Consider hiring a private CPS attorney or learn how to hold your appointed lawyer accountable. Misconception number 3. CPS is just investigating, nothing official yet. Listen, it's been my experience in almost 40 years as a lawyer. The CPS investigation is your case. Everything you say, every interaction you have with the social worker, it's being well documented. By the time they file the case against you, they've already built their version of the story. What have you built? You thought you could outsmart and outtalk the social worker and convince him or her not to file a case against you. That's a really bad strategy. The fix? Treat every CPS case, every CPS intervention, every CPS contact like a legal deposition. Respond with your attorney. All right, misconception number 4. I'll start services once the judge orders them. In many cases, services take weeks to schedule. Delaying them makes it seem like you're unmotivated. The court may treat early services as voluntary compliance and reward you for it in terms of your credibility or getting your child placed back with you. So many times people tell me, and even to this day, I just had a client who hired me and I explained to them that they should start the services. And the retort I have is, number 1, I don't have time. Number 2, isn't that an admission of my guilt in the child abuse case? Well, first of all, you got to make time. This is a case you're involved in, involuntarily involved in, and you got to treat it like it's the most important case that you'll ever be involved in your life. And no, it is not an admission of guilt. Let me repeat that. Participating voluntarily in services is not an admission of guilt. And in my experience, when you participate in services, you get credits from the judge and from the social worker. So don't poo-poo the services. Start your parenting classes, your drug testing, and therapy as soon as possible. Now, if there's an issue regarding anything, like a possible crime or you're going to test dirty, that's something that you should discuss with your attorney. Discuss it early and often. Everything you talk about between you and your attorney is confidential and protected by law. Let me take a quick pause here. If you've heard yourself in any of these points, that's okay. Now you know. But knowing isn't enough. You need a strategy. You need motions and court filings. You need legal protection. Call my office today or book a consultation. And if this live stream is helping you at all, please donate so we can keep the truth out in the public. All right, misconception number 5. My child was placed with family. I have time to relax. The court clock is still ticking. Relatives are not permanent placements. CPS can switch placements or move toward adoption behind the scenes. I can't tell you the number of cases where a child was initially placed with grandma and then moved for whatever reason. Sometimes good reasons, sometimes made up reasons. But CPS can take your child from the relative placement where the child is right now. So the other problem is this. You know that relative that took the child and promised to wait for you to get the child back? Well, unfortunately, because of human makeup and biology, that relative is probably going to become attached to your child over the days, the weeks, the months. And all of a sudden, that relative may be fighting you and trying to keep the child away from you. How many times have I seen that? Hundreds and hundreds and hundreds of times over my career. I'll say thousands. I'm reminded of a famous case in Orange County where the grandmother was too busy to take the child, so she gave the child to her sister. When they hired me, I said, "Are you sure you can trust your sister? This is a cute little blonde-haired, blue-eyed child. Are you sure she's going to be willing to give the child back when the time comes?" I was assured by the grandmother that that was going to be the plan and that she could trust her sister. My client, the mother, also agreed that her aunt would never do anything to stab her in the back. Well, maybe 18 months down the road, we have a trial, and we're fighting to get the child back from from the great aunt, the grandmother's sister. We lost. The judge found that the relationship between the child and the great aunt, the grandmother's sister, was so strong that it would cause a detriment to return the child to the mother. And by the way, the mother had gotten back her 3 or 4 other children from another relative who didn't stab her in the back. So we got back the other 4 children, but the baby stayed with the great aunt. It caused the family a massive breakup to this day. And this probably happened 10, 15 years ago. I still am in contact with one of the relatives, the grandmother's husband, the grandfather, and we're still in contact on social media. Last time I chatted with him, things never changed. The great aunt went on to adopt that child and keeps the child away from the family. So the fix: stay aggressive. Keep building your reunification defenses like your child is in foster care. When your child's with a relative, your child still is in foster care. It's just called relative foster placement. Misconception number 6. I just need to explain my side to the judge. I can't even tell you how many times I've heard that statement. Listen, CPS has already submitted documents and evidence against you. In my experience, judges rely on those reports heavily, and they're supposed to by law. Telling your story without proof and evidence is a huge gamble. Get with your attorney early. Get a list of witnesses that will testify on your behalf. Get a list of witnesses that will testify that the social worker's reports or parts of the report are untrue. Get with your attorney. Discuss the documents, the evidence, the pictures, the videos that can help disprove the social worker's case and help prove your case. The fix: document your truth and start documenting it early. File your declarations, your exhibits, your documents, your videos, your pictures. Use your lawyer, whether it be court appointed or private, to control the narrative. Misconception number 7. I'll hire someone if I lose my first hearing. By the time you have your first hearing, and if you lose, The court has often found that there is a reason for court intervention and or jurisdiction. Your rights have already become restricted. Reunification services become harder the longer the child is removed. The fix, if you're going to retain counsel before the detention or jurisdiction hearing, do it then. Don't wait till the end. I would say maybe 40% of the people that call me tell me this: Mr. Davis, next week, next month, they're going to have a hearing to terminate my parental rights. Right then, I already know in most cases you've already been involved in the case 12 to 18 months. And I stopped asking this question: why did you wait so late to hire me? Because I already know the answer. The answer people tell me most of all are, number one, I thought the social worker was going to be fair. Number two, I thought the judge would see that the social worker was lying. I mean, after all, this is America. Truth and justice are always overcome falsities by the social worker, right? Truth and justice always wins out. Wrong. Talk to a private attorney or get working with your court-appointed attorney. If you get the sense that your court-appointed attorney can't or won't help you, there's no need to complain about it. Okay, it's just something that you can't change. Sun rises in the east, sets in the west. That's it. Don't argue. Just go out and make changes. Talk to other attorneys. Consider hiring a private attorney. Misconception number 8. I've got 6 or 12 months, plenty of time to get the child back. I don't need to hire a lawyer. Funny thing, I met a guy in court in another county than Los Angeles this week. And he walked up to me and he was dressed perfectly, suit, tie, white shirt. And he goes, "Are you Vince Davis?" I go, "Yeah, I'm Vince Davis." He goes, goes to shake my hand. He goes, "How do you like my court uniform?" And I'm kind of looking at him like, "What are you talking about?" He goes, "Your video. You told us what to wear at your court uniform. I've got my court uniform on." I said, I said, "Hey, did you like and subscribe for the algorithm?" He said, "Yes, I love your videos, blah, blah, blah." And then he goes on to tell me how he's getting screwed in the case. And he says, "Well, can I call you?" And I said, "Absolutely." So we exchange numbers. I go on to my other case. And he sees me talking to my client there. Well, after the hearing and I'm leaving the building, my client says to me, "Hey, you know what? That there was a guy you were talking to. He's not a client, but he talked to me about how I liked you or disliked you with you representing me." And I said, "Oh," I said, "I hope you gave me a good review." She said, "Absolutely." I told him he should consider hiring you. And I said, "Oh, what did he say?" He says, "Oh, he's going to wait. He's going to wait." He already told me in our first conversation that they're trying to terminate his parental rights. Case has been open, it was my guess, like 12 to 18 months. But he's waiting for the social worker and the judge to do the right thing. He'll probably call me after his parental rights are terminated and ask me, what can I do to get my rights back? And in most cases, by then, it may be too late. In California, reunification services can be terminated after 6 or 12 months of services being given to you. At the 6-month review, the court can end services and schedule a termination hearing, which will lead to the adoption of your children. The fix: treat every 30 days like a deadline. Show measurable progress. And I've done live streams and videos on this, how to document and participate in your reunification services. I'm not going to talk about that now or today during these office hours, but find those videos and watch them. Misconception number 9. I'll wait to appeal if things go really bad. I get a lot of calls from people who want me to do the appeal for the termination of their parental rights. Last week, I got a call from a woman, Mr. Davis, thank you for those YouTube videos. I've been watching them for years. Oh, great. I hope they helped you. Well, I just lost my parental rights and I'm waiting to find someone to do my appeal. They've given me a court appointed attorney, but I don't know. Maybe I want to hire a private attorney. My first question was, and I shouldn't ask this question. If you've been watching my videos for months and months or years, why are you just now coming to me or calling me and asking me to do your appeal of the termination of your parental rights? And of course, the answer is always the same. I thought the judge would be fair. I thought the social worker, the governmental agent, would do the right thing. I never believed that they would really terminate my parental rights and try to adopt my child to strangers. After all, this is America. They don't do things like that in America, do they? They do. Know your appellate rights. Prepare for an appeal early during the case. And make sure you file your appellate paperwork on time. Can't tell you how many times people call me and they've actually missed the filing of the appellate cases. Misconception number 10. They won't terminate my rights. I love my child. I'm the best parent in the world. Termination of your parental rights is a legal decision, not an emotional one. Judges terminate rights based upon timelines and legal standards. It would be nice if you document your love. It would be better and save your rights if you document your participation in the case plan. If you document why the social worker's reports are false. It would be better if you have, and your lawyer should take the stance that you have to prove your fitness and prove your stability. Don't assume that the social worker will do it for you, and don't assume that the judge will see through the social worker's inaccuracies or exaggerations or outright lies. Misconception number 11. I can fix it later when I'm doing better. CPS and CPS cases move quickly to permanency. Permanency means placing the child out of your custody forever. Later doesn't exist in the timeline of the CPS dependency court. There is no later. I try to explain that to people many times, in many calls. They don't believe me because they believe that CPS and dependency cases are like, a criminal case. And in their criminal case, it's been continued a year. I have a criminal case right now that I think has been going on 18 months, and we haven't even gone to trial yet. Yeah, that's a criminal case. This is a CPS case. Different laws, different standards, different speed. The rationale is they want the child to be permanently placed out of your home if you can't get the child back, and sooner is better than later. There's an actual code section in the Welfare and Institutions Code, and I would guess it's true in all states. You can't get a continuance. You cannot get a continuance unless there's quote unquote good cause. A lot of judges tell me, your client hiring you is not good cause to continue a case. Not good cause. I did a case yesterday where I came in yesterday. The judge accepted my substitution. The trial is actually today, this morning, in another county. And I moved to continue the case because I didn't even have the file. How was I going to do a case today, a trial, on a very complicated abuse case without the file? I made my motion, and hadn't the attorneys on the case all agreed to it, I'm going to bet that that judge would not have continued the case. My substituting in is not good cause. He could have prevented me from substituting in unless I said yesterday at 3:30 that I was ready to proceed to trial today at 9:30. He even mentioned this. He said, "Look, I'm a fill-in judge, and from what I understand, he does a lot of criminal stuff in that county." He said, "If this were my case, I wouldn't even let you sub in today," or words to that effect, because trial is tomorrow. I got lucky. Everybody agreed to it. Cases was continued about a month. I can get the file and prepare for trial. Don't think that that's the rule. Don't think that that's going to happen every time. Like I said before, continuing a case is very limited, and it's very limited by law, not because the judge doesn't like you or likes you. It's just the law. The longer you wait, the more likely the court rules it's too late to get that other chance. Don't assume that they'll give you another chance. That's a bad assumption. Treat this like it's your last chance. Every hearing, treat it like it's your last chance because it might be. All right. If you're in a CPS case, every minute matters. You cannot afford to wait. The system is not waiting for you. If you want to fight back and fight back smart, I invite you to give me a call so that we can discuss your case. Help me or let me build a plan, a strategy, and help you implement it. Call my office today, 888-888-6582. It's there in the bottom right-hand corner. Book a consultation. I'm attorney Vince Davis. This is not your CPS is not your friend. Time is not your friend, but I can be. Let's go to war for your family. We'll see you next time on CPS Hours, office hours tomorrow at 8:30 a.m. Before I go, I'm going to try to take some questions. Not that many questions today in the chat. Betty Joe from Facebook says, "What do they mean when the child has attachment disorder if they remove the child from the foster home?" Betty, that's a great question. Basically, what they're saying is the child's been there in the foster home so many months, and the child has developed a psychological, emotional, and physical bond with the foster parent. Okay, that's what happens to children. What happens to us? We bond with each other in social circles. So if you remove a baby that's been, in the foster home 18 months since birth, if they remove that child's going to suffer mentally and psychologically from being placed somewhere else, even if it's the relative. Even with you, I've had foster parents get attorneys and fight me and my client to try to keep the child at the 12-month date. I think I've even seen it a couple times at the 6-month date. And that just dovetails into what we were just talking. You do not have time. If you're going to get this child back, do it early. If you're going to get this child with a relative, do it early. Because the first thing you're going to hear if you wait, oh, the child has bonded with the foster parents. It's going to be detrimental for us to move the child. I hear it all the time. Okay, Erica McDonald from Facebook says, but they don't think it's a detriment for the child to be taken from their parents. That's retarded. You're right, Erica. In my opinion, they give more substance to the bond, the 12-month bond between child and foster parent, than they give between child and parent who has raised the child all its life. It's retarded. I'd agree with you. It's the law, unfortunately. So, as I told someone recently, let's quit criticizing, because we can't change people. Can't change this social worker, can't change the judge. But the law is the law, and you can't change that. So, knowing what the law is, knowing that it may be quote unquote retarded, what are we going to do to win to get the child back? That's what you need to be focused on. Okay, Erica says, I don't think my son has gotten a bond with them because every time we end our visits, he starts hitting the foster parent. The reason for your child doing that is varied. Could be varied because the child is reminded about you, and now the foster parent is going to take the child away. But I can assure you, when they get home, the foster parent gives love and affection to that child, gives food and water to the child. The child will tend to forget about that and rebond with the foster parent. Okay, Christina Reynoso from Facebook says, we're taken separated from siblings and friends. Okay, Christina, I'm not following that one. Okay, here's Eric again. I have a 2-year bond with my son. Bonds are made to be broken. The longer your child remains out of your care, the bond decreases. Let me say that again. The longer the child remains out of your care, the bond between you and your child is minimized. Erica says from Facebook, it was just me and him, and that's what he's used to, and he wants to come home. I already know it. You know what, Erica? I believe you. I believe that statement. Do you think that that's going to help you get your child back? And if you do, on a scale of 1 to 100, how important is it? That's what you have to ask yourself. And do not believe for a second that because you have a great bond, that's going to help you get that child back. What's going to help you get the child back is winning your trials, proving the social worker wrong, and participate in any plan that the court has ordered. That's just the bottom line. I'm sorry, I'm the messenger, but I'm asking you to look at this case legally. Don't look at it with your heart. All right, Christina Reynoso from Facebook says, the pain from being separated, have Erica hire you. You know, Christina, I cannot make people hire me. That's something that they have to decide. They can find other attorneys as well, but please find someone that's going to help you. All right. Erica, what can I do to get my worker to give me more time when I'm doing what I should be doing? I don't understand. And I think they've been doing this from the beginning. They've been keeping them from me, not giving me my visits, not giving me more time. This is a complaint I hear all the time, Erica. And there are things that you can do. I've done videos on this. Listen, you can talk to your attorney and file what's called a 388 petition in California. I don't know what it's called in other states. You might want to Google and find out. But you can request the judge to do this by way of a 388 petition. Sometimes attorneys ask for it just off the cuff because custody and visitation is always at issue at every CPS hearing. It's good that your attorney do that, but it's better if they file the 388. Erica says no and not very important. I'm not sure what you mean by that, but then Erica says, yeah, I'm doing all that stuff, but they're asking me to do, and then it ends, probably to do more. Yes, that's why you need to file the 388 with your attorney. Talk to your attorney. You know, when you file the 388 and present the evidence, that's the only way the judge is going to find out what you're doing and how well you're doing. Okay? So consider that. File that early and often. Yes, you can file 388 more than once. All right, that's the end of our questions. So that's the end of the show today. We'll see you tomorrow on CPS office hours at 6:30 a.m. Pacific time. Bye-bye.
I'm just so very thankful again to have them and to have found them, and I would recommend them to anybody that's going through this, because it's hard and you're gonna make mistakes, and the mistakes can make the situation worse, but they come in and they just know what they're doing. And again, to have his number at your dispense, like no other attorney does that. And they get back to you right away, and again, comfort you, fight for you. They just reassure you, and when you're going, like I said, going through this nightmare. And I'm so blessed to have found them.